work better? Y'all been able to hear me better the last couple days?
Yes.
Okay.
Usually, yeah.
Usually.
Yes, I've been able to hear you, and I appreciate it very much, Your Honor. I don't know whether it was brought to your attention over the break, but there was a lot of personnel, courthouse personnel in here. We're looking at the courthouse situation, and it was conveyed to me, and I'm just making sure it was conveyed to the court, that there is a concern that it is hard to hear most everyone, other than me and some other particularly loud person, that if you're sitting on the back two benches in the courtroom where the last couple of jurors would sit, that they can only hear two of the 20 million lawyers in front of the bar. And I'm not sure if one of the other people is you, but obviously if the jurors can't hear you, we're going to have a real problem.
That has not yet been brought to my attention. I will follow up on the acoustics and make sure I understand what may have occurred at lunch, because I was not involved. I was taking care of other matters.
There are turf issues in this courthouse, and the reason I brought it up is sometimes people feel that it's not their place to say.
The flash drive that I was given before lunch, I have reviewed. I'm going to give that to the clerk as courts 2.
I have one.
We had one.
And I think Mr. Goff had put several exhibits in there. May have become courts too, about some of the photographs on that side.
But I saw it with this. I'm going to call this courts 10.
Very good.
This is going to be courts 10, and then we'll figure out which one we're in. I'll keep a list. How's that? Okay, so that's been submitted. The court did review the flash drive in camera, which was the Duggan body cam. All right. During the, defendants are all present, represented by counsel, and we are on. The court provided to counsel, right at the beginning of the lunch break, a proposed preliminary jury instruction. Well, the easiest way to do this is do it the way we would do it for a charge in a charge conference. So, from the state, any objections or exceptions to the preliminary instruction?
No objections to the preliminary instruction. The only thing I noted, Your Honor, was that on page 7, the third paragraph down, I instruct you, ladies and gentlemen. And then the fourth paragraph, again, to maintain the integrity of the jury system.
It's a little repetitious.
Correct.
Yeah, it's intended that way.
That's all I wanted to make sure, because it seemed like maybe it had been a cut and paste, but obviously it was intentional. All right, then no objection to the charge.
Yep.
Oh, I'm sorry.
That's good. Page 2, first line, the defendants are charged in the indictment with A crimes.
Thank you. With crimes?
Second paragraph, line 4, 3 into 4. This presumption remains with the defendant unless and until? I think unless and until are used together again.
I'll look at the actual,
Okay.
that is a standard charge. Okay. That's the language I think came out of standard charge.
And I just had a question about page 3, last paragraph. 1, 2, 3, 4, 5, 6 line down.
Okay.
They make motions regarding the conduct of the trial.
Correct.
Is that the right language?
Yeah,
Okay.
that's the direct
Just
language.
sounded awkward.
Yep.
Okay. Otherwise, nothing further.
It's different when you actually see it in writing, right?
Your Honor, I would ask that on page 2, the first paragraph, that it should read, the defendants are presumed to be innocent, period. And then each defendant enters upon the trial of the case with a presumption of innocence in his favor. Presumption remains with the defendant, and we join unless and until overcome by the state, etc. Then we have a motion with respect to the last line on the third paragraph concerning all doubt or to a mathematical certainty. And then on page 5, there is a typographical error at the second to the last line on the second paragraph. It says you missed instead of you must disregard it. Oh, this was just, I put this in, it helped me, and I think it might be an omitted comma. On page 6, second full paragraph, the third line from the bottom, until actual deliberations begin.
Let me get there.
Actually, I'm on the
Second paragraph.
second paragraph where it's 1, 2, 3, 4 lines up. Until actual deliberations begin, and this part's fine, that is, until after you've heard all the evidence, comma, the lawyer's closing arguments. In order for me to read it properly, I have a comma in there, and have been fully charged on the law that applies to this case. But I just noted that for myself.
I will submit that change to the Superior Court at its next
That would be
conference.
you. I read that you were on the committee, right?
No, not anymore.
Previous?
Due to the commas and parentheticals and other things that get debated, I decided there were other matters that I might be better charged to address.
Well, I noted that, and I wasn't sure if it was omitted by accident. Then on page 8, the second to the last sentence of the top paragraph, it seems odd to say that you'll consider all, as a whole, all the instructions I've given you and will give you, it says during deliberations. I suspect that's before deliberations. But if that comes from the pattern, you're not actually giving them instructions during deliberations.
No, that's from the pattern, and I guess you could read that a couple different ways, but
Well, I think it's read, you should not single out any one instruction during deliberations. And then the parenthetical, of course, is you should not single out any one instruction, but must consider as a whole all of the instructions I have given you and will give you during deliberations.
With that emphasis, yeah, it does make better sense. So now I agree with that. See the importance of a comma.
well, the comma exists there, though.
Yes, it does.
Yes.
And now it makes better sense to me. I know what you were about to say, the one we used to use with our children. Yeah. Let's eat, Grandma, comma, let's eat, Grandma. Yeah. So that's why it's important. On page 8.
Commas save lives.
Commas save lives, that's what we've told the boys. On the page 8, the second to the last sentence, whether or not you make such, it's a typo, it says and inference, it should be
Such
an
and, yep.
inference. And I know you're thinking right now how annoying it would be to be my law partner, so. Page 9.
Well, just for the
citizens-
record, since I have some staff attorneys here, I did not give this to my staff to proof. This was just
This
done.
is not a criticism, but I'm just my mistake.
No, because they want me to make sure everybody knew that we're squared away. And we're normally much more squared away.
Should have brought it right to their attention. Page 9, under citizen's arrest, the last sentence of the first paragraph, a person may arrest him upon reasonable and probable grounds of suspicion. I don't think that comma is in the statute, upon reasonable, comma, and probable grounds of suspicion. It makes it sound like two different things. But I think reasonable and probable in the statute is straight through, without the comma.
I'm not sure where I would have gotten the comma from. But I'll look at that. However it's in the statute, is however it would be in the charge. Again, they're not going to be getting a copy of the preliminary charge. Just so everybody knows how I usually operate. The preliminary charge to me is exactly that. It's to make sure that the groundwork is set for the jury to understand its roles and responsibilities, and it's just an explanation to them of where the court expects them to be in the trial. The final charge, though, which repeats a lot of this, ultimately I do send out a written copy of the charge with the panel. But of course, if there's going to be exceptions or objections to that, I'll hear from the parties on it. But my general practice is to send out a copy of the charge.
Very good. That was all I saw in this charge, with the exception of the issue concerning the motion on the removal of all doubt.
Mr. Goff.
We would adopt all of the suggestions made by Learning Counsel. I also remember, I think it was on page 2, and Mr. Sheffield was pointing out an issue. I think the charge referred to defendant rather than defendants plural. And if it did, although that's probably the pattern, in this case, it might make more sense to refer to defendants in the plural.
Well, I tried to go through and make sure it was each defendant or defendants, so they're referred to both ways. If anyone sees one in there, just let me know. I mean,
But I have more, I think, important issues. And first, let me acknowledge, the court's under no duty to give a pre-charge at all. And I understand that. Nor can a pre-charge be expected to be as lengthy or detailed as the charge the jury received at the end of the case. And I'm certainly not suggesting that. But we are discussing some of the legal principles in this case. And if we're going to do so, I would humbly submit that we do so completely and accurately. And I sense that the court has been perplexed at times in the past when I have suggested that charge issues needed to be addressed, and probably also irritated because of all the counsel in this case, I have probably been the last to get anything before the court. So I understand the dual issues there. Nevertheless, given the importance of the case, I feel that we should address some issues earlier, sooner rather than later. The charge on burglary, I would respectfully contend, is incomplete.
now, I do want to point something out, though, before we get too far into it, just so everybody understands what the court did with this charge. I was asked to give a preliminary charge on some issues that may come up. Burglary in the first degree, burglary intent to steal, criminal trespass, citizen's arrest are all directly out of the Superior Court charge book. The only charge here that is, the only charge here that the court had to pull together is what I have marked here as the Bruton charge, which really isn't a Bruton charge, it's just an evidentiary instruction. So before we get too far, what I tried to do for simplification of the initial charge was simply go to the existing pattern charges, fully realizing and understanding that at the end of this case, once all the evidence has been submitted, the court's going to have a charge which addresses the evidence presented at trial.
I wasn't in any way, I didn't mean to imply the slightest questioning or criticism.
No, and it wasn't. I was simply explaining to everybody my thought process here, because this is the preliminary charge. This is very basic. It could be expanded upon, but what I didn't want to do was provide a charge that ended up not being consistent with the evidence and trying to explain too much.
And Your Honor, I believe that it was originally the state's motion to have those in, and I believe what your direction to us was that we should all agree upon this. And I did receive responses from Mrs. Hogue, and she said, yes, we're going to agree to this, and we have some alterations, and that was her motion. And so, unfortunately, this is the first time I'm hearing that Mr. Goff is not in concert with the rest of us, because we've all agreed to.
Well, and we don't know that yet. I just wanted to do that because, and I guess the other part of this, and I have received your submission, for example, on citizen's arrest, which is a proposed charge, as well as a whole bunch of supporting law on that. I've looked at it, okay? But again, at this point, since all of the evidence in the case has not been presented, normally I don't put any charges on the law in a preliminary charge. And so in order to avoid the problem down the line of having something in the preliminary charge that doesn't actually end up getting in, I've tried to be very careful with it.
All I can do this afternoon is bring some issues to the court and ask the court to consider them. And I don't expect that every suggestion I make is going to find its way into the charge of the court. It may be that none of them do, but because we will have this conversation at the end of the case, and I suspect probably during the trial as certain issues come up, I feel if the court will indulge me, it would be a productive exercise.
No, that's fine. I just want to make sure we're all on the same page.
And I think we are. Your Honor, the problem isn't that the charge itself is wrong. It's that it's incomplete for this particular case. To be, in all candor, if this was the usual case involving a burglary, it wouldn't have taken 17, 18 months to get here. This is a case that involves a unique juxtaposition of relatively uncommon principles of law. For example, in the burglary statute, my concern here is that there is nothing for the jury to decide as to whether the English residence is a dwelling covered by the burglary statute. Now, my concern is that the way this is the state is presented, and I think the state is the one who suggested this particular charge, is inviting the jury to consider whether the English residence is in fact a dwelling under the statute. I think, consistent with Georgia law, that a house under construction, which is so completed as to be capable of sheltering people, animals, or property, constitutes such a structure under Georgia law. It doesn't matter if the dwelling was occupied, unoccupied, or vacant. So I think that that additional language, which comes out of Georgia case law, and I don't think the state disputes that that's the law, I believe that should be included in here. So with all the other considerations the jury legitimately has to consider, tough questions in this case, we're not sending them down the rabbit hole as to what a structure or dwelling is under Georgia law. Now, furthermore, I think the case law is relevant that to prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. I believe that language is appropriate. It's less important than the first part. But here's my concern, Your Honor, and this dovetails into the charge on criminal trespass, which dovetails into the charge on citizen's arrest. With all due respect to learned counsel, all of whom disagree with me, there is no criminal trespass in this case. Either Ahmaud Arbery committed a burglary on either February 11th, previous occasions are certainly February 23rd, it's a burglary or it's nothing. Under Georgia law, it's clear that if theft is the only crime that the evidence would suggest, you're not entitled to a charge on the lesser offense of criminal trespass. And in this case, there's no reason to charge a jury on criminal trespass because either they find there was a burglary or they find no crime at all. There's no factual scenario under which they could find a criminal trespass. Now, whether that's good for the state or bad for this defendant or that defendant, I think that is the law. And that, again, takes us to the citizen arrest statute, which...
Before you move on,
I'm sorry.
I'm sorry.
Yeah.
We want to adopt the argument on burglary in terms of how structure is defined, as well as breaking the plane. We would like to adopt that. We did not move for that originally, on behalf of both McMichaels.
Thank you, sir. No. I'm glad you stopped me.
Mr. Sheffield just yelled squirrel. We stopped.
I'm just pleased anybody agrees with me in this case. I'm a happy camper. Your Honor, with respect to citizen arrest, I submitted that proposed charge and authority a long time ago because I think it's a central issue in this case. Here's my concern, and I've expressed it to the state and I've expressed it to my learned co-defendant counsel in this case. This absurd path we're on where the court, doing what good judges do, which is in default, for lack of any other reason, charge a statute. And I get that. And the state appears to be happy for the court to charge the statute, and the co-defendant counsel seem happy for the court to charge the statute. I have a problem with it. And here's my problem. There is no criminal trespass in this case. There's a burglary or there's nothing as far as Ahmaud Arbery is concerned. And I think you've heard enough of the evidence in this case to understand why I say that. There's no reason, and there's no question as to whether the structure is covered by the burglary statute. There is absolutely no reason to charge the first sentence of the citizen arrest statute because it's not this part of the statute that covers or governs felonies. A private citizen may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If we're talking about a misdemeanor, that is the law. But there is no misdemeanor upon which to conduct a citizen arrest in this case. Nobody can tell me what that would be. There's no reason to charge it. The second part, punctuation, or issues about punctuation go back to 150 years. Whatever the court decides on that is fine. But what's going to happen, Judge, is you're going to read this statute, okay? I think you are, and you're charged for the jury. The state is going to get up there and find, no disrespect to the state, some clever way to talk about knowledge and immediate presence, and I'm sure they can find one. They're going to say that there's no citizen arrest because it didn't take place in the presence and immediate knowledge. The McMichael lawyers are going to get up and say, well, that's just not true. The law is that you can arrest someone for a felony without the person being in their presence and within their immediate knowledge. And apparently everybody but me is happy with this scenario. But here's what I see, and I say this as a former law clerk. I see the jury coming back with a question. What do we do with this statute? And the default response for most judges is going to be to say, I cannot give you any further information unless the parties have agreed, which they won't. You're going to come back and tell the jury, I have charged you on the law, and that's what you are apply. And then the jury's going to go back there, and we're going to end up in hung jury land because they're not going to be able to decipher these two competing versions of what the law is without the direction of the court. And to avoid all that, since it has no relevance to any of the issues in this case under any plausible scenario of the fact, there's no reason to charge first sentence of the statute. The second sentence, the part that applies to felonies, is all that should apply. Now, I think there's things that should be added to that. I don't think that necessarily has to be in the pre-charge. We can discuss that later. But it is fundamentally a bad idea, with all respect to my learned opposing counsel, to leave the jury sitting there through the whole trial trying to discern the difference between the first sentence and the second sentence, and all this confusion of whether it's a dwelling place or not, or what this presence and immediate knowledge is. We're inviting these individual jurors to go down their own personal rabbit trails for 2 weeks, and then at the very end, we're going to get two competing versions of the statute, and in all candor, if we get there, normally you're just going to tell the jury, you give them the charge, and then they're going to be stuck. I don't want to be there. Take out the first sentence, because there's no misdemeanor under any set of facts in this case. It's a burglary or nothing. And if anybody, I'm sorry, go ahead.
No. I thought you were done with that.
Well, on that citizen arrest issue, I am.
I respectfully disagree with Mr. Goff. And here's why. We should have the whole statute on citizen's arrest, and we should have criminal trespass. Fundamentally, it's the probable cause in the minds of the defendants, otherwise known as reasonable and probable grounds of suspicion, as the old citizen's arrest statute put it, and not whether Mr. Arbery ever committed any actual crime. He may not have, for all we know. It's whether the defendants had reasonable and probable grounds to suspect that he was fleeing from the commission of a felony in sentence 2. And I do agree there's probably no evidence in the case that anyone witnessed or had immediate knowledge of a misdemeanor. But the first sentence is both felony and misdemeanor. It applies to both. The second sentence of the statute only applies to felonies. But again, furthermore, and of most importance in this discussion of the charge, is that there doesn't have to be evidence that Mr. Arbery actually committed any crime. It comes down to the reasonable belief of the defendants when they attempted to detain him.
Which is why we're not getting into great depth in the preliminary charge, because I don't think this addresses that either way, and I'm neither agreeing nor disagreeing. This charge is general enough where I believe it covers what we're going to at least get into in the evidence of the case. Whether the ultimate charge on citizen's arrest reflects exactly what you're saying is still, I understand, and again, I referenced Mr. Goff's significant brief on citizen's arrest before we got started. The court is not at this point acknowledging anything but what is out there in this pattern charge. The idea here is simply to give the jury an idea on what citizen's arrest is without getting into all of the arguments of counsel simply in the preliminary charge. Okay.
I have nothing further to add to that. I did have a few other points, if the court will bear with me. I talked about burglary, and I missed something, and I want to go back to it. The court is charging generally a bad intent to steal. However, there is also case law not reflected in the pattern charge that makes a consideration not just whether items of value were present, but where there seems to be no other reason for entry. That is to say, when no other motive is apparent. There are cases that discuss that, and I believe, although it's not in the pattern charge, I don't believe on intent to steal, it's relevant to this particular case. We've heard stories about maybe speculation, somebody was looking for water, maybe speculation, somebody wanted to go to the bathroom. I believe that that part of the Georgia law on burglary should be included in the charge on intent to steal. I also believe that an instruction on flight is appropriate here. If we're going to charge the jury about intent to steal, we should also charge them on flight. The combination of flight, intent to steal, plus flight gives you probable cause for a burglary, almost as a matter of law in this case. And if you're going to charge on intent to steal, you charge on flight. I think you have to have both. And that's all I have to say on the burglary. And I'm sure some other people want to have their say.
Not on that, I wanted to talk about the reasonable doubt part when you're done.
Okay. All right.
Well,
Yes.
yeah, the state's still here. The state could address the court. I mean, hi, I'm the state. With regard to part of what Mr. Hope said, yes, I'm about to agree with him on the fact that I know goes down to the whole citizen's arrest part should come in. With regard specifically to flight, Mr. Goff's just recent flight argument.
Okay.
Since January 10th of 1991, it's been reversible error to charge the jury on flight. However, recently, the Council of Superior Court judges decided that it may be advisable to give such an instruction if requested by defense counsel as a limiting instruction. Evidence of alleged flight or similar acts like escape, bribery, intimidation has been introduced. Usually this would be introduced by the state. So evidence of alleged flight, such evidence is governed by the rules concerning circumstantial evidence you have already been given. Furthermore, you may only consider it if you find more likely than not that the defendant actually committed such act and that the reason, I think for the flight, was because of consciousness of guilt or to evade the charge now on trial. My assumption is that the defense would ask for this to be changed up to the evidence of alleged flight has been introduced, because they're assuming and going to argue that he's fleeing. Such evidence is governed by the rules of circumstantial evidence. Furthermore, you may only consider it if you find more likely than not that I'm assuming they're going to do, the victim actually committed such act and that the reason was because of consciousness of guilt. But I just wanted to bring it to the court's attention that this is new, this flight pattern, and it's a limiting instruction. Therefore, I think it only comes in well after the evidence has been presented.
And it is one of our requests to charge at the conclusion of the case, Your Honor.
And to further simplify the matter, Your Honor, although I don't think it needs to be in the court's preliminary charge, as I understand Georgia law, although in civil contexts, the law is that where a reasonable man would investigate further before instigating a prosecution or making an arrest, he may be liable for failure to do so, which would seem to impose on the McMichaels in this case, and arguably on Mr. Bryan, a duty to inquire. And the reason I'm bringing it up, because I think there's going to be some discussion tomorrow in opening statements about what I would call the Nancy Drew problem, which is there's a right to arrest, but there's arguably no right to investigate. However, I think you can investigate as long as you're not breaking the law, and in fact, one could make the argument applicable to this case, that the McMichael defendants were under a legal duty to ask him what he was doing before they arrested him. And certainly that would go to the reasonableness of their actions on the day in question.
However, if I may, on that note,
And I may be taking us off in a different direction. However,
in both the interview the Hogues gave and the radio interview Mr. Sheffield gave to Court TV, they both used some key language, and I noticed the key language was that the McMichaels were effectuating a citizen's arrest detention so the police could come and investigate. And these were key words. A citizen's arrest detention so the police could come and investigate. That obviously, there's no such thing as that. And I only bring it to the court's attention right now because it's of concern to the state that conflating, we get to detain and hold somebody so the police can come and investigate this is not what citizen's arrest is. And I just agree with Mr. Goff that that concept is concerning to the state. And I will just leave it at that. Obviously, if that's what's put together in the opening tomorrow, I will be objecting because that's a misstatement of the law. But I just agree with Mr. Goff that detention and to hold somebody so the police can come and investigate is not what a citizen's arrest is.
I wasn't implying that that's what happened, but I do think the evidence, as I understand it in this case, will be that this started as a consensual encounter, driving up on the side of the road, and I'm not trying to put words in anybody else's mouth. This started as a consensual encounter. Stop, we want to talk to you. And under the law, flight is certainly relevant. And if you have an obligation to inquire in good faith before arresting somebody, the fact that someone won't stop and talk to you kind of explains the escalation on this day. At least that's one defendant's view of that. I'm certainly not speaking for the McMichaels on that. And I certainly think that it's relevant. But beyond that, I'm ready to move on to the next issue, if I may.
Sure.
Your Honor, I also believe that we are charging on burglary. I think that we are entitled to a charge also on, I would leave it to the discretion of the court, others may feel differently, either carjacking or motor vehicle theft. The evidence we believe will support that. And of course, theoretically, and I've gone through this exercise, you can find all kinds of potential crimes out there, but I think that carjacking or motor vehicle theft are reasonable to charge the jury about. It focuses the jury's attention on one of the important issues in the case. And I'm going to stop and see if anybody agrees with me.
We adopt on behalf of both McMichaels.
Oh, I'm sorry, adopting a carjacking
Do we not vote?
preliminary.
Instruction.
Oh, okay, yeah, all right.
I can now say we adopt on behalf of both.
One took me off guard. Very good.
When I was there adopting, is simply that carjacking should be added to the preliminary charge.
Yes,
Okay.
his motion to add it, so we can specifically.
Or in the alternative, motor vehicle theft, if the court feels uncomfortable going that far.
And, Your Honor, the state's sole intent with requesting this preliminary charge was because numerous witnesses misused these terms. We've got breaking in, burglaries, criminal trespass, which Greg McMichael says, and on video with Officer Rash, so that they know exactly what citizen's arrest meant. The sole purpose of this was so that when people used terms of art that we all know very well as lawyers, that there would be some explanation for this jury in advance as to what those terms of art were. At no point in time does Mr. Bryan say carjacking. He says he was, after he cornered him, he attempted to, or what appeared to be, reaching for his car door. So this idea that we're going to make out of whole cloth, after I took my car and cut him off so close to him and cornered him, he appeared to be reaching for my door handle, and I sped off so he couldn't get to me, turns into a carjacking. The state's very, very concerned about inserting at this point in time carjacking or theft by motor vehicle into this case. And in fact, if we're going to go down this route, the state will just withdraw wanting any of these charges at all in advance for the jury, and we'll just go with the preliminary charge up till You should not single out any one instruction, but must consider as a whole all of the instructions I have given you and will give you during deliberations. The state would be perfectly comfortable in taking out all of this stuff if we're going to go down this road right now. It was simply to assist the jury in understanding some of the inartful language some of the witnesses, especially the McMichaels, were going to use in this case.
And if the state wants to withdraw that, that's fine, but I'm going to adopt the motion, and their withdrawal doesn't matter. We're entitled to the charge on these substantive principles, and the suggestion that the solution for the state is simply to withdraw substantive charges and leave the jury uninformed, I won't speculate as to what was going on behind that. But, Your Honor, I'm ready to move on to the next point unless somebody else wants to further address that one.
I would just like to add, Your Honor, there is, I don't know if the state's going to put it in, but Mr. Bryan says Ahmaud Arbery was trying to get into his truck, so he slammed into drive and jumped out away from him. That he was trying to reach for the handle of the car to get in the truck, and there'll be testimony about Mr. Arbery trying to get into Mr. Bryan's truck and what that meant. So I think there's a good faith basis to help the jury understand that before the trial.
I'm ready to move on. Your Honor, I seem to be the only lawyer in this case that thinks that the jury needs to be charged, the pattern charge, 3.16.40, arrest, right to resist unlawful force in making an arrest. The only change that needs to be made is where it says police officer, it should say a private citizen is authorized. How is the jury going to make any sense of this case if they don't understand that Mr. Arbery has the, and I'm not saying that he was correct or that this is in fact the case, but how are they going to process the evidence in this case without understanding that not only is there a common law right of citizen arrest, there is an equally old and ancient right, still recognized in Georgia, a minority of jurisdictions at this point, to resist, first to resist an unlawful arrest, but second, to resist the excessive use of force in a lawful arrest, and to wait to the end of the trial to inform the jury of legal principles that they probably wouldn't have any idea of, is going to put a situation is the jury's going to be looking back over weeks of notes trying to figure out how they apply that principle of law, because I expect they're going to be blind, other than the people with law enforcement training, they're going to be blindsided by that issue. Even several of the jurors who are career federal law enforcement officers are unfamiliar with citizen arrest or the right to resist an unlawful arrest or to resist the excessive application of force in the context of a lawful arrest. And with all due respect to everybody else who thinks I'm crazy, to me, that's really the primary issue in this case. There's no question that there was probable cause to conduct an arrest. That's just my opinion. The issue is not whether there was probable cause to conduct a citizen arrest. The issue is going to be, ultimately, whether the Travis McMichael, and perhaps Greg, used excessive force in effectuating a lawful citizen arrest. And the flip side of that, which is why the state disagrees with me, is the jury's going to have to decide, even if the arrest was lawful under Georgia law, whether Ahmaud Arbery was entitled to resist what he had perceived to be an excessive use of force. Instead of looking at this primarily as a citizen arrest case, you can or you can't, the real issue in this case is whether the McMichaels or Arbery or both employed the excessive use of force. And to not let the jury know that that issue is out there is a disservice to the jurors, and I think it's a disservice to the justice process. Not that anybody's trying to not serve justice here, but this is a critical issue in this case. Because to simply say whether it's a citizen arrest or not decides this case, that's not the end of the inquiry for the jury. That's going to be the beginning of the inquiry for the jury. So we can't ignore this issue. And I have, and I don't mean any disrespect to co-counsel, but it's like watching three-dimensional chess through a fog or a mist and trying to figure out what's going on. I can't follow all the machinations here, but we're at trial, and I have to look out for Mr. Bryan, and I feel that these legal principles need to be addressed, among other things, not necessarily addressed in the preliminary charge, but we've got lesser offense issues that inevitably are going to, and inextricably going to be intertwined with this concept of resisting arrest or resisting excessive application of force in an arrest. And I just think we need to have the jury be aware of this issue and not blindside them with this at the end of the case and have them coming in here with questions. Can we rehear this part of the testimony or rehear that part of the testimony? Because at the time we heard it, we didn't know why it was important. Why put ourselves in that position? I think that needs to be in the pre-charge. On that subject, that's all I have to say. I have 2 or 3 issues left, depending on how this one goes.
Well, that's what closing arguments are for. Here are the facts, and this is how the law that the judge is going to give you applies to those facts. And so while I have actually submitted excessive force and resisting lawful and unlawful arrest as jury charges, the state doesn't necessarily believe that it's appropriate in the pre-charge. The court is absolutely right. This is a minimal overview to be given right before opening statements, and it's unnecessary for them to have an entire charge at this point.
If I may, one of my frustrations in this case is we haven't even begun to explore how you adjust the pattern charge on use of force to the facts of this case. And I understand why the state would like to look at this as a self-defense case. And I understand why the co-defendant's counsel looks at this as a self-defense case and justification. It's easy. If one party is the aggressor, they're in the wrong. If the other party is the aggressor, they're in the wrong. But it's more complicated than that. It's not just who's the aggressor, it's the context in which the aggression takes place. This is an arrest situation. As a matter of law, one is not required, a police officer, for example, is not required to engage in an even fight. You know, in the old days, they used to say, if he brings his fist, you bring out a club. If he brings out a knife, you bring out a gun. And arrest is never intended to be an equal application of force. You can't simply give the pattern charge on use of force in this case without creating real problems. And we need to be focusing beyond that to the finer points of this case, which actually is what the jury ultimately is probably going to be looking at. And I just think, once again, we need to be focusing more attention on whether one or both parties in this used excessive force and how we charge the jury on that concept instead of, with all due respect, what seems like an infantile analysis of who's the aggressor, because it's more complicated. They can both be the aggressor in this case. Having said that, I'll move on to my next one unless Ms. Donikowski wants to be heard again.
I'm good, thank you, Your Honor.
Your Honor, we believe that we are entitled, I won't say entitled, pre-charge is kind of discretionary with the court, but we would ask the court to charge good faith. That's, I think, part 3 of the citizen arrest charge that I had previously submitted. Your Honor, relying on Henderson v. State, 95 Georgia Ave. 830, cited in State v. Hemd, H-E-M-B-D, 232 Northwest 2nd, 872, Model Penal Code, Section 3.07, in parentheses 4, Commonwealth v. Klein, Massachusetts case from 1977. It's also referenced in what I previously submitted. We contend that good faith on the part of Bryan, defendant Bryan, is a defense in this case. And we believe that the jury should be charged on that. And we're asking for that because Mr. Bryan isn't coming to this with a gun. He's coming to this with a cell phone. He is unarmed. And we can quibble about how to most accurately define that. The bottom line is he's unarmed, notwithstanding whether a 5,000-pound vehicle can constitute a weapon. He is essentially unarmed, and he is coming to the aid of the others involved in this case. And good faith is a defense, and we would like the jury charge with respect to Mr. Bryan that good faith is in fact a defense. It doesn't matter in the end whether the McMichael defendants were authorized to conduct a citizen's arrest or not. That he at all times acted in good faith, and that based on that, even if the jury were to find the McMichael defendants guilty of one or more of these offenses, that they could still acquit Mr. Bryan based on his good faith as a third party in this situation. I don't expect the state's going to agree with that, But the sooner we have that discussion, the better we'll all know what the applicable law is going to be.
The state disagrees with that. There is no good faith exception. The thing is, Mr. Goff is partially right. There's mistake of fact. And that is an appropriate jury charge, not to give pre-charge, because that is once again something for a charge at the end of the case based on the evidence presented. So we ask that good faith not be given at all.
Your Honor, I think we've asked the court for enough when it comes to use of force for a pre-charge. I'm not going to ask the court to add any more law on the use of force, but I would, again, implore the court to consider whether there's a lot more to this case than whether or not there's a citizen arrest. Excessive force is what this case is really about, by one or both or none, and that'll be for the jury to decide. But we should at least get them started on that path as they're hearing the evidence as to what those issues actually are, because they're only hearing half the law in this case. It's not just citizen arrest, it's also the right to resist arrest. Thank you.
Since we're still addressing the charge, I believe, Mr. or Ms. Sugg, you had the argument on the reasonable doubt portion of the charge.
Permission to remain seated so I can navigate my stuff. Thank you. If we look at the pre-charge on page 2, paragraph 3, the last sentence, that's what's at issue in the motion I filed, and I don't know if I filed this before or after the pre-charge thing came up. Yeah, I saw that. I was still on the way. I had filed it originally intending it to apply to the final charge, but since reasonable doubt's in the pre-charge, it applies here as well. So in paragraph 3, just to read that whole paragraph, it's not long. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. And this is the sentence at issue. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. Without reading the whole next paragraph, but just pointing it out in it, is a second type of doubt, and it's called vague or arbitrary doubt. So the pattern charge acknowledges two kinds of doubt. One is reasonable and one is vague or arbitrary. Reasonable doubt, of course, is the one that the state has to move the minds of the jurors beyond. And the problem with that sentence is several problems, but it's misleading and it's confusing and it's actually faulty or erroneous. And to illustrate it, I'd like to call the court's attention to a recent case. I don't know how to pronounce this name. I'll spell it and try to pronounce it. It's Debelbot versus the state. Debelbot. And it's at, I just have the Southeast 2nd site. It's 839 Southeast 2nd, 513. It's a 2020 Supreme Court case. And I bring it up for illustrative purposes because of the mistake made by the prosecutor in this criminal case. A mistake that illustrates the problem with the charge, not a mistake I think that any of these fine, experienced, excellent prosecutors would make. I don't think they would. And I don't know who this prosecutor was, but this is what he or she did. During closing argument, I'm reading from the opinion, the prosecuting attorney attempted to explain to the jury that proof beyond a reasonable doubt does not require proof to an absolute mathematical certainty. That is, the law does not require the state to prove the guilt of the accused with 100% certainty, and that the standard of proof in a criminal case is not readily susceptible of quantification. In doing so, however, the prosecuting attorney set the bar far too low, going so far as to argue that something less than a preponderance of the evidence would be enough to authorize the jury to find the Devilbots guilty. And then they quote from the closing argument, and I just do a little piece of it here. And this is the lawyer in closing argument. Reasonable doubt. The judge will charge you on reasonable doubt. Just keep in mind, and he will charge you, reasonable doubt does not mean beyond all doubt. It does not mean to a mathematical certainty, which means we don't have to prove that 90%. You don't have to be 90% sure. You don't have to be 80% sure. You don't have to be 51% sure. It does not mean to a mathematical certainty. And of course, that was completely wrong, and the court pointed that out. And so I bring it up to illustrate not what I think anyone over here will do. I know they won't argue like that. But here's a lawyer confused about it. And I have raised this many times in many of my own murder cases. And it's never been granted. It's never been taken out. And it's made it up to the Supreme Court now twice. Once in Anthony v. State, which was a murder case I tried. And you can see how things went. It went on appeal. And this was one of the many issues. And then later in Rowland v. State, another murder case I tried, you can see how that one went. And it cites the Anthony case, but Rowland and Anthony.
You get one sided to the other on the same issue.
That's right. But here's what, and I think Your Honor might appreciate this metaphor I'm about to give you. It's kind of like the dead bird thing. But here's what the court said in Anthony. They said, the fact that the sentence of which the appellant complains.
Right in front of me was introduced by the word however.
Yes, you've seen that. If I read the end of it, I'll give you my analogy on what I think this type of ruling means. However, it does not change the meaning of all doubt or mathematical certainty. Even assuming that the use of those terms amounted to error, we will not reverse the judgment on that basis because the charge as a whole properly informed the jury of the state's burden of proof and the meaning of reasonable doubt. And that was Rowland citing Anthony. And so the metaphor I came up with for that kind of ruling, where they're saying that if you put that possibly assume erroneous sentence into the whole charge, everything's okay. So it strikes me like this. It's like saying to the jury, well, other than the worm that has burrowed into my apple, the apple as a whole is still edible. Just eat around the worm. So there's this worm in the charge, and I'd like to get it out of the charge because I think it is misleading and confusing. I have spoken to jurors. This is anecdotal evidence, of course, and they have expressed to me their confusion about what this does. What it does, I think, is it diminishes the burden of proof by introducing the idea of all doubt in the paragraph with the reasonable doubt, which hasn't even been defined yet, and before the other kind of doubt has been introduced at all, which is vague or arbitrary doubt. So if you modify all doubt by inserting the only other kind of doubt that's been mentioned so far, what you're hearing, if you do that, is all reasonable doubt. So the sentence is possibly heard as, the state is not required to prove the guilt of the accused beyond all reasonable doubt or to a mathematical certainty, because at that point, no other kind of doubt has been mentioned. And the contrast to vague or arbitrary doubt, it apparently doesn't even apply to that sentence. So it's partly the placement of the sentence, and as I put in the brief, it creates an ambiguity. The particular one that it creates is called an amphiboly, and my favorite example of it is Groucho Marx. who said, "I shot an elephant in my pajamas this morning." How he got in there, I'll never know. It's that kind of ambiguity that this creates. But on a more serious note, it is confusing to the average juror, as it was confusing apparently to a bar card holding prosecuting attorney in this Devilbot case. I guess it was confusing. I don't know how that lawyer thought that you could reduce reasonable doubt all the way down to preponderance practically. And then the second part of my argument is the mathematical certainty part. I'm sure everyone has read René Descartes' Discourse on Method, published in 1560. But common sense, the phrase doubt or reasonable doubt, common sense often starts out as a novel theory or an idea or a belief that over time just infiltrates the groundwater, seeps through the sand, and finally reaches the aquifer, and then we all drink from it. I mean, until 600 years ago, it was common sense to believe that the sun revolved around the earth, and that the earth was flat. And then we changed our minds about all that when somebody came up with a new idea that was more useful and more effective and more powerful. So the idea that that mathematical certainty is some kind of mental state different than beyond a reasonable doubt is, I think, a holdover from the days when modern philosophy started with Descartes being the ultimate skeptic who set out to doubt everything until he realized, well, I can't doubt that I'm the one doing the doubting. And we've all heard the little phrase, cogito ergo sum, I think, therefore I am. And then we're off to modern philosophy, a subject I enjoy and I know a little bit about. So mathematical certainty, I submit, Your Honor, is no different than beyond a reasonable doubt. And the example I use is this, and then I'm done. Mathematical certainty that 2 + 2 = 4. Nobody in this room doubts that. That is a mathematical certainty. By the same token, nobody in this room doubts that we are, in fact, right now sitting in the Superior Court of Glenn County, Georgia. We are just as certain of that fact, which is a physical fact about the world, as we are about the mathematical fact that 2 + 2 = 4, which is just an idea. And the reason we're equally certain is because we know how to use the words in the right way. We know what 2 and 2 plus and equals means. So I think this is antiquated carryover from what the law does. As we all know, it often is 50 years behind science. There'll come a time when intent and all of the issues we have with moral culpability being applied in criminal law may be completely different than they are today because of the discoveries being made by science. Maybe, maybe not. We don't know. But the law catches up eventually, and I'm just trying to prod it along here and get rid of one little sentence in a pattern charge that's been around a long time. And usually judges tell me, well, it's in the pattern charge and I'm going to keep it there. I'm not going to change something that we've been saying for 150 years. So I'm just taking my little hammer and hitting the rock, and maybe one day it will crack. So I ask Your Honor to remove that sentence from the pattern charge.
Your Honor, we join in that motion.
From the state.
Thank you. Your Honor, it's a pattern charge. We ask that you not remove all doubt and mathematical certainty. And the reason is because the jurors are regular people. And you know what regular people say? You got to prove it to me beyond a doubt. Okay? They actually say that. I've actually had them say that that's what they believe the state has to prove. I've actually said, or jurors have actually said to me, well, I'd have to be 100% certain, meaning that that's the burden they expect the state to prove to them. I've had jurors tell me that, yeah, I'd have to see it with my own eyes in order to find somebody guilty. Now, were they trying to get out of jury duty? Probably, when they said these things. But jurors are not lawyers. And some of them back there may turn to each other and go, well, I think beyond a reasonable doubt means we have to be 100% certain. Or I think back here that it has to be beyond all doubt. But that's not what we're held to. We're held to the standard of beyond a reasonable doubt. So this language is not directed at anyone but jurors who do not know the law, and it's directed at jurors so that they understand that the state is not required to some sort of mathematical formula, and that the state is not required to eliminate every single doubt they might have. There is a charge on circumstantial evidence. There's a reason, because in this case we do have a video. But what we don't have a video of is what happened on Burford Drive. We don't have anything about what happened on Burford. So we don't have anything when Mr. Bryan went ahead and backed up to change Mr. Arbery's path to go up Holmes. We don't have that on video. But that's something that the state's going to have to go ahead and show and prove. And there's circumstantial evidence, and there's the statements of the defendants to prove that. But the state is not held to a standard other than beyond a reasonable doubt, and this is language in the pattern that was put there to assist jurors who may not understand the standard and actually attempt to hold the state to a higher standard. Thank you very much.
Your Honor, if we're going to talk about it, you know, there's a substantial federal body of case law on reasonable doubt, and there's some great language in there which would address the concerns that's raised by Ms. Dunikowski about how you would handle the most serious of your own personal affairs. And maybe she'd like to, I'd be happy to work with her on coming up with adding that language into the charge. You know, just because we've been doing a charge for 150 years doesn't mean it's right. For 125 years, we were charging about hypotheses of innocence. Somehow, which was great language for the defense, and we don't get that anymore. I think it would be appropriate in a case of this gravity for the court to take a serious look at the charge on reasonable doubt.
Okay. Sounds like we have addressed the arguments then in the preliminary jury instruction. Let me just note the comma in citizen's arrest. That was the court's error. That comma does not exist after reasonable, and I have removed it. So that's consistent with 17-460. The court is going to keep with the few edits there that have more to do with proofreading than anything else. I'm going to go ahead and make those changes. Beyond that, I'm going to keep the charge the way it is, including the language just argued about reasonable doubt. The court doesn't simply rely, I realize some people just simply rely on the charge, but there's more to the charge. The charge usually relies upon some precedent set by the courts. So that precedence, and Anthony and Rowland, which have been referenced here. I've got the language about, for example, however language dating back to 1892 with McTire. And there's also other cases that address the charge itself and well-settled principles, Coleman v. State, for example. And Williams v. State, which talks about as a fundamental rule in Georgia, jury instructions must be read and considered as a whole in determining. All of that leads the court to the denial of the motion to remove that language. I do also point out the state, to its credit, I assume we'll give credit where credit is due, I think cited Delbot. Delbot. In States 4.56, which the state actually was the one arguing not to use percentages with regard to reasonable doubt. So I hope everybody, well, it sounds like everybody is on the same page with how to properly argue, at least that improper argument with regard to reasonable doubt. Okay. So that's the preliminary charge. I'll get that cleaned up. It will be ready for tomorrow. During the break, the court again looked at the body cam footage that was submitted. Why don't we go ahead and argue the McMichael's motion in limine regarding the Officer Duggan body cam.
Did I understand the court's ruling correctly, implicitly denying all of the requested changes to the charge, or is the court taking those under advisement?
Those are denied for the preliminary charge. Again, I have not, the court is open to argument with regard to the final charge of the court, but with respect to the preliminary charge, yes, those motions are denied.
Thank you, Your Honor.
Okay.
Grab the state's motion, Your Honor.
Just for the record, Your Honor, I'm sorry, check over.
It's fine.
We object and want to preserve the record on the alterations to the pre-charge that we requested. By saying thank you, I appreciate the court's consideration, but I want on the record that we're preserving our right to have the charge corrected, the substantive charge corrected. Thank you.
Thank you.
We are moved to limit the playing of Officer Duggan's body cam. Now, there are some things on his body cam that the state is trying to have access to. It looks like the part that shows the defendants interacting with each other at the scene prior to being interviewed by law enforcement. Let's see. Also, perhaps to show Travis McMichael's demeanor in the aftermath of the shooting. I think the body cam may show some of that as well. That's really not. Also here, depicts in real time what was seen by the second responding officer when he arrived on the scene. Shows where the defendants were located at the scene in relation to each other. Do you have the motion, Your Honor? The
I
state's-
do. I have my notes that
Okay.
I'm looking for. I'm listening, and
That's fine, I understand.
I've read the submissions.
Yeah.
So I'm following you. I'm just
Okay.
trying to find my notes.
Shows where they were located at the scene in relation to each other. Also it says without sound in the first 30 seconds. It shows Duggan interacting with and speaking to defendant Travis McMichael. This is important since it's believed that this is when Travis McMichael stated to Officer Duggan that he had shot the victim. These don't appear to be issues that we're concerned about that the body cam reveals. Those are not what we're concerned about. There is, however, a moment where Officer Duggan kneels over Mr. Arbery. And I think the court has now seen that. Turns his body over. He's giving pressure to some wounds. And the body camera is hovering 6 inches or so, maybe a foot over the body. Very, very graphic, very explicit. The question becomes, what's the relevance of the state and what's the necessity of that in comparison with what we've just put forward in our motion, which is the substantial inflammatory nature of what that video is showing at that moment. And so it may be that the state could speak a little bit more on 401 and we can speak on 403. But certainly the things that the state desires out of that video that are not included in the moments where the camera is kind of hovering over Mr. Arbery's body in that way, and I don't know if the court could acknowledge there's several moments before that happens, then there's a good maybe 30 seconds to 45 seconds, maybe even a minute of being over Mr. Arbery's body. There's a different position of the camera at that moment versus when he first arrives on the scene. So the question then becomes, is there a necessity for the camera viewing the body in that state at that close proximity? Does that make sense, Your Honor? Okay. And I guess the questions as we anticipate, or the evidence that the state anticipates to give to the jury is going to include that Mr. Arbery was in fact shot and killed, that he was shot and killed by Travis McMichael, that his injuries caused that the shooting and the injuries as a result of the shooting caused his death, and where those injuries are on the body and how they led to his death, etc. So we're asking the court to consider alternatives to that particular moment in that video. Are there other ways to show the injuries? Certainly. There's other photographs, still photographs, either at the scene or at autopsy. The medical examiner we've both talked to have confirmed that Mr. Arbery died upon being shot, and that even was deceased before falling to the ground. That what's heard in the video, there are sounds that are characterized by some of the personnel on the scene. Those are not signs of life. Those are not signs of struggle to live.
Well, there's two things going on there. There's one, you can sort of hear in the video what I think is just the officer's breath. That's not what we're talking about. What you're referring to, I think, is just the officer's and I don't want to get into details because I don't know
Sure.
if that video has been played anywhere.
It has not been played anywhere.
So without getting too far into it, the officer makes a statement about his observation of the individual and what he thinks he may have heard to, I believe it's the EMTs that are arriving on scene.
There's a couple officers that do that, make statements what they classify as a quote-unquote death rattle.
Okay. I'm just with Doug, and the only one I'm looking at right now is Doug. I'm just trying to understand what we're talking about there, because being told what I was going to hear, I was a little confused over what I was supposed to be listening to for argument. What I heard was him talk about what he heard,
Okay.
and then while there with his hand on the chest, you can hear him breathe, him being the officer. But I think it's after that he then describes to the EMTs what he thought he heard. So it's his descriptive. It's not that actual sound that gets picked up. At least I didn't hear that.
Okay. So there is a part of that video that's very inflammatory, in the same way that autopsy can be inflammatory. And I perfectly recognize the state's right to put up their case. The question for the court, though, is to try to balance that in a way that is not going to incite the jury in a way. And so if the interests are such that the state has to prove certain elements, I am asking the court to engage in a balancing test over whether or not that particular portion of the video needs to be played, and whether the state's burden can be satisfied through other means of photographs that will depict injuries, testimony that will testify about various facts in existence at the time they were observed, as well as the medical examiner's testimony, etc. So I'm just asking the court to engage in a balancing test under 403. The way that I read the state's response to this is they have a need to present certain things. There are a lot of avenues for that. We are going to see the shooting in the case. We are going to see Mr. Arbery fall. We are going to have testimony that is as a result of being shot and that he was killed as a result of those shots. To then hear what we will, I think, later learn in medical terms is simply the expiration, although is not indicative of life or consciousness or awareness or still the ability to be resuscitated. I think that's what becomes inflammatory. And I'm asking the court to limit that. The state can still have the portions of that video that satisfy these other important aspects that they feel need to come in, like the position of the defendants. I'm not saying we're not going to see Mr. Arbery's body on the ground there on Holmes Road. I assume that we're going to see photographs of that and a lot of evidence of that. It's just, as the court has now seen, that part of the video is very inflammatory. Thank you.
Your Honor, we would join in that motion.
From the state.
Thank you, Your Honor. Officer Duggan is the second responding officer to the scene. He arrives and does have dash cam video that has absolutely no sound to it. As the court noticed, he hits his body cam video, it comes up, and then there's like a a little bit, 30-second delay before the sound kicks in. And he can be seen pointing at Travis McMichael, who's standing next to Greg McMichael off to the side in the shade. They are standing near the shotgun and near Mr. Arbery's body. Minshew is the only other officer on the scene. So you've got 2 officers, you've got 2 pickup trucks, a shotgun, and 3 men who are not law enforcement officers there. And there's a series of what do we do because officer safety, and is there a way to save this person? The reason it's important is because it shows exactly what took place as far as Mr. Arbery on the ground. Mr. Arbery is face down. Greg McMichael admits that he ran up and pulled his arm out in order to check for a weapon. At this point in time, Officer Duggan, when he comes up, rolls him over. And you can see the extent of the injuries, and you do see them. And this is, for lack of a better way to say it, this is real. This is real. And to tell the jury, oh, we're not going to show you what really the result of pointing a shotgun at someone is. Travis McMichael left his house with a shotgun. Then he got out of his car with the shotgun and pointed it at this young man, and then he shot him with it. And this is the result. And Officer Duggan is an officer who had to go to the scene. This is a human being who has to stand over this young man and put gloves on. And he's thinking, what can I do for him? And he puts his hand over it, and he then says, there's nothing I can do for this gentleman. And the other part of all of this is that Travis McMichael is standing probably right there during this whole entire thing and seeing this. The state has no idea if the defense is going to get into Travis's demeanor at the scene. He's upset, he's in shock, he's all these things. Well, that explains a lot of it because this is the result of his actions. And we think it's very probative because it shows where everybody was, the condition of Mr. Arbery, what Mr. Arbery actually had in his hand, and this sort of intimation out there that may or may not be in these jurors' minds that nobody ran up, including the defendants or the police, to assist Mr. Arbery. Obviously, it's going to be explained to them by the ME that the first shot killed him. Just because, like in the movies, he didn't fall down immediately, that didn't mean that that first shot didn't kill him. It did. He just kept going because it didn't hit his heart. So we want to show all of those things, and we think it's very, very relevant in this case to show exactly what the aftermath is and what the officer did, rolling him over, looking at his wounds, and they'll be able to actually experience that through the body cam and see that. My understanding, of course, and I'm just going to segue right now, is that the defense has no objection to the dash cam video, which is stationary and very, very far away, and you do see Officer Duggan doing all of these things from a distance. But it's just the body cam video that the court has seen. We ask that the court allow it, that it is it's more probative on these issues of exactly where everything was, everyone was, the evidence, and how Mr. Arbery was, including his clothing and the condition he was left in on the scene, than it is prejudicial for these jurors. Thank you.
Just a very brief conclusion, Your Honor. As the state has said, we do have the beginning of the video. We do have the car dash cam video. That shows the scene. It shows everybody is. We have Officer Minshew, who is first on scene, who has video on him as well. That shows where everybody is and is still playing when Officer Duggan arrives. And it's not relevant what the officer's experience was. That's not we don't need to understand the emotional experience of Officer Duggan. This is obviously a careful balance, but the state's needs, and this is what the court would do in circumstances like this, the state's needs are satisfied through other relevant evidence that will be admissible and doesn't have that same substantial inflammatory impact. We understand this is real. We're not shying away from that, Your Honor, but this is you've seen it now. Thank you.
Well, yeah, I watched the video and considered the arguments of counsel. I'm denying the motion in limine. We'll permit the body cam footage. I might put the court's order into a written order into the record just so we have it. I've got a number of cases. Instead of rattling through those cases, I'll just maybe put those into a written order so that everybody's clear on where the court stands on it. But generally, the video would be admissible to show the manner of death, how the body was found, the wounds, and how the defendants and the witnesses interacted at the scene at the moment the police officer arrived. Although I'm not sure I've got the cases here, there are, I believe, some cases that talk about the state's entitled to prove its case the way it believes the evidence is appropriate. The court does have to balance that out with 401, 403. And having done so, I'm going to go ahead and permit it. I think this would be a good opportunity, and I'm going to say this again probably tomorrow and then maybe again at some point during the trial of the case. The state makes a good point. That video is a very real depiction of a scene that may be shocking to some. This court does not expect, and I would hope everybody would respect the fact that there would be reactions in the courtroom to any evidence presented or any outbursts even not associated with any evidence as it is presented. We are going to have a very small gallery, so I don't expect there to be a lot of folks here, but there's a lot of emotion associated with this case, and so I say that, and this is not the only case I've said that in. A lot of more high-profile murder and sexual assault cases that I've been involved in, I've said the same thing, and I realized as I was watching that video that I probably hadn't said that, at least in this courtroom, so I do want to make sure that everybody understands. If you don't feel like you will be able to sit in this courtroom and do so in a way that's not disruptive, I do ask that you go ahead and take a step outside if you need to. All right, the last matter I have then on the McMichael's motions is the vanity plate.
And I also made the state aware of our a motion in limine that we wanted to make, and I was going back over the state's list of exhibits that they wanted to play during opening argument, and one of those is the photo in life.
I thought we'd gotten Pat. Don't we just have one
what?
one photo in life?
Yeah, we wanted to move in limine to not use that photo, and I made the state aware of what we were asking for, and that I wanted to make the court aware that we're objecting to the use of that photo in life, and just wanted to bring it up to the court now. We can do the vanity plate since it's on the menu, but we also wanted to bring up that, and I made the state aware of that. It's not in writing, it's an oral motion in limine.
Okay, well, let's go ahead with the motion on the vanity plate.
Okay. We have what appears to be a photograph taken of the truck that shows the old Georgia state flag vanity. It's not a vanity plate, it's just an old flag plate that is the one that the court allowed us to ask questions about during jury selection, that a lot of people saw as a symbol of racism. It appears that the state is not intending to make this case about race or racist motives unless the defense opens the door to that type of evidence, wherein the defense would intentionally put in the character of Mr. Travis McMichael. That plate, though, is something that the state has responded by saying, this is a plate that Mr. McMichael chose to put on the front of his truck to drive around town and to advertise to the world as sort of who he is and what he's about. So I think the state, as it's characterized it to us or to the court previously, I can't remember if the state has gone on the record with it at this time, but it certainly has shared with us that they intend to argue that this is a statement by the defendant, and it's a racist statement by the defendant, or one that is certainly suspect and could demonstrate motive to go after Mr. Arbery on this day for reasons other than investigating or trying to delay somebody through citizen's arrest. I don't believe the license plate is really visible in a lot of the video, but to the extent that it is, we would ask that the court limit the playing of any photograph or video of the front plate, because it's inflammatory and because it injects into this case something that we all have been trying to avoid and trying to obtain jurors who don't have strong opinions about this as well. and for that reason feel like it's an improper comment, at least as we understand the state intends to use it, on Travis McMichael's character, which is not in evidence until he places it into evidence. And so we're asking for the court there's a photograph, if the state wants to show the truck and its placement, that we at least blur out or black out the license plate on the front of the truck.
From the state.
Two things. First off, that is not what the state is intending, is to put in character evidence of his motive. Character evidence is character evidence. Motive evidence is motive evidence. The state at this point in time is not anticipating putting in its case in chief motive evidence of racial animus. And there is no limitation. I don't want Mr. Sheffield to be under the impression that the limitation is when Travis McMichael opens the character door. No, if Travis McMichael opens the motive door, the state's going to walk through it, because the state is entitled to present motive evidence. The fact that the state at this time is not anticipating tendering motive evidence of racial animus does not mean that that's not going to happen when Travis McMichael takes the stand and starts talking about his motivations. Because it's not character evidence, it's motive evidence, and there is no need for the state to provide advance notice of evidence of motive, even though we have in this case provided that with ample notice, out of an abundance of caution, filed it as a 404B, and then withdrew it as a 404B because it's not coming in our case in chief. And then we did actually provide it to the defense on a jump drive with all of the racial animus evidence that we anticipated tendering should the issue of Travis McMichael's motive come up. So I don't want the defense laboring under some misapprehension because I didn't speak up right now and inform them that character and motive are two separate things. So right now we don't anticipate putting it in, but we do anticipate, if it comes up, to discuss his motive, and one of his motivations being racial animus. With regard to the vanity plate specifically, the vanity plate is something he specifically put on his brand new truck that he purchased the truck after January 1st of 2020. There's been no indication that it's something that it came with the truck and he just didn't remove it from the truck. It's just that he placed it on the truck. He placed it on the truck and drove around in the truck for everyone to see that on the very front of his truck. To now come into court and complain that it somehow shouldn't be put before this jury, and the state has a couple of problems, Judge. Which photo are we talking about? This truck is in about 10 of the state's crime scene photos. And then it's also can be seen vaguely, it's very fuzzy, in Officer Duggan's camera when his car is there. It can be seen repeatedly in all the body cam videos as the officers are walking around. They can see it very, very clearly. So the practicality of the motion is that it's almost impossible for us to blur this out every single time. I actually wouldn't know how to blur it out of body cam video. I'd have to edit that, and I wouldn't even know how to do that. But we have numerous crime scene photos. The fact of the matter is that this is something Travis McMichael put on the front of his truck. He wanted the world to know this. He put it out there to see people, for people to see him driving around with this particular plate on the front of his truck. Little disingenuous at this point to ask that it be blurred out as if somehow it's not relevant to this case. And it is relevant to this case because there comes a point that's in Mr. Bryan's video where Mr. Arbery is running down the road on Holmes. The white truck is coming toward him. At that point, he turns around and runs back past Mr. Bryan's truck. This happens at the blue mailbox. So the defense, of course, is going to argue, well, there's no evidence he saw it. Well, he turned around for some reason. Whether he saw that on the front of the truck or not, he was looking at the truck, and that's what's on the front of the truck. So at this point in time, we ask that you deny this motion because this is a choice Travis McMichael made. It would be as if he chose to put on a T-shirt that had the Confederate flag on the front of it and then somehow wanted us to blur that out. That was his choice of clothing that day. This is a choice of something he put on his car to advertise to the world as he drove around in Brunswick. And we do have circumstantial evidence that Mr. Arbery did see the front of this truck because when the white truck is coming toward him, Mr. Arbery turns around and starts running back past Mr. Bryan. We ask that you deny the motion.
There's two issues going on here, and I think it's worth addressing. The first is the fact that the plate exists on the front of the truck. Okay. The second is an interesting issue because it dovetails into something we spoke about earlier today that's under advisement, and that's whether or not probation is relevant. To me, there is parallel logic in the two arguments. Let me explain. The defense argument in the probation matter that it should be in is that it is evidence, and I'm not going to be very artful with this, but it's evidence that it's not character evidence. Instead, it is informative with regard to Ahmaud Arbery's actions when confronted or when this chase was going on. Okay. Parallel logic, and this is what I'm trying to figure out, maybe we'll get it when you come back up, we'll talk to the defense. Parallel logic is